Along with plaintiff appearing on behalf of the respondent, Ashley Anderson.
Right. And we have Lucas Anderson here. Good afternoon. Thanks for your patience. Okay.
Here on February 21 on Mr. Anderson's request to reappoint a guardian ad litem. Your Honor basically took it under advisement at that time and indicated that if we were unable to reach an agreement because I had a settlement proposal going out, that you would consider appointing a new GAL in this case. We have at least communicated in regards to settlement. We are not in a position currently where we're going to get this thing settled at this time. So the question is whether or not you do intend to go ahead and appoint a new GAL. The last time we were before you, you asked whether or not it should be the same GAL. Both Mr. Anderson and I agreed that it should probably be a different GAL, as there were some concerns about the lack of investigation by the prior GAL. We had at that time received the 3 names, and I believe that Ms. Day was the first one on that list, but to be quite honest, I didn't see that in the clerk's notes, but I had it in my notes. So the question is that your intention is to appoint a GAL? And then the question will be, if so, how are we going to handle those fees? And I would just ask to be heard on that further.
So, yes. And so I will appoint a GAL. I know that Miss Langford was the last one. I think probably my initial thought was I'm going to just reappoint her. However, 2 things. 1, both parties had concerns about her previous report. 2, she just asked to be removed from the list for a temporary period of time. So the next 3 names we have are Tina Day, Twyla Corey, and Keith Lawrence.
And I don't have any objections to Ms. Day.
Any objections to Ms. Day?
That's the only one I had written down that I would like to object.
Okay, so then does Twyla Corey?
Who are the other 2? So
Twyla Corey and Keith Lawrence.
I guess we're fine with Twyla.
Okay.
So then the question is as far as fees, I can tell the court that my client was involved in a fairly significant automobile accident this last year. She is still out of work on L&I. She's currently receiving about 60% of her pay. And she is the one that's responsible for paying essentially 100% of the community obligations. So she has extremely tight finances at this point. We had originally indicated in my client's reply declaration that if you were considering to reappoint or to appoint a GAL, that Mr. Anderson pay 100% of that fee. Alternatively, we would ask that the court consider having a county pay with a review for either an increase to private pay and or reimbursement by the parties after everybody's had an opportunity to fully flesh out their financial resources at that time.
All right. Any comments on the fees?
Yeah, I mean, I financially don't make a lot of money either. So any way that we can split the cost or find alternative ways, that would be for the best. I don't want to put a burden on anyone, but we do need to get answers as well.
I have an order that was provided by Lucas Anderson here in front of me. It is, and I appreciate you providing that. It is outdated. So I don't know if Ms. McLean, would you be willing to submit?
I don't think that I have seen a proposed order.
I just got it from the clerks. So, and it's actually an order reappointing Miss Langford. And so we're going to need a different order anyway.
Yeah, I didn't receive that order. So I would just remind Mr. Anderson that if you are filing documentation or submitting documentation to the court, you need to be sure that you include me in those communications. So yes, I can certainly prepare a new order for the court.
All right. And what I will authorize county pay initially, and then we can review that once we receive our reports.
Okay. So let's see. Do you want to schedule a presentation, or do you want me to submit that ex parte, or to submit it to Mr. Anderson for signature and then submit it to the court, or?
The latter, please. And so
let's schedule a presentation then, just in case.
we could schedule a presentation just in case, for how about the 4th of April?
You can do that.
And then, so, Mr. Anderson, we're going to have an order sent to you that Ms. McLean's going to draft. And it's just, shouldn't be anything controversial in there, just appointing Twyla Corey as the GAL, listing that it's initially county paid and then it'll be reserved for any other determination of fees. And then some dates for review. So
let's assume that the order isn't entered until April 4. That would make the report due July. Is that right? No, that would be April, May, June, July, August 4. Would be when the GAO report would be due. And then do you want to do a final GAO review? Could we do the 22nd, August 22nd at 1 p.m.?
sure. Does that work for you?
Yeah.
Okay. So August 22nd, 2023 at 1 p.m. for final GAL review. And then do we want to request of Ms. Corey any kind of interim updates or a check-in maybe in May?
That's up to your honor. I don't know that we necessarily need that. I don't think that there was an interim in the prior GAL report.
Yeah,
so I think doesn't the new form have a new review now to make sure that everybody's paid fees? But this is county pay, so we wouldn't need to do that.
It's a review for payment and just that the packets are out and are being worked on. I don't anticipate that portion being a problem in this case. That the packets aren't returned, assuming Ms. Corey starts fresh. I don't know what she's going to choose to do. So
do you want to have a review in May?
Yeah, let's set a review for May 9th. That's a little over 6 weeks.
And
that's just an interim GAL review in case there's any concerns or issues. And I don't want to complicate things, but if you hear from Ms. Corey, both parties hear from Ms. Corey, and she doesn't have anything of concern, and their parties are agreed, that can be struck.
This is just to make sure that packets and information. So you're not expecting an interim report from her?
Unless I would expect something from her if there's concerns, I guess, and that can be an oral report. But it can be struck if things are okay and everybody's provided everything that needs to be provided.
Thank you.
All right. And then I guess Mr. Anderson will strike that, did I say April 4 presentation, assuming you sign off on that and it gets back to me, and then I'll sign it and just file it so we can get started.
Okay, sounds good. Thank you.
Perfect. Thank you.
A request to amend the temporary orders. We are asking the court to modify the temporary order relative to the spousal maintenance. Excuse me. Previously, the court ordered Mr. Rapp to pay Ms. Rapp $1,250 per month in spousal maintenance. And it also ordered him to pay $3,450 per month in installment debts. some of those debts of which benefit Ms. Rapp for purposes of paying for her automobile insurance, her cell phone, and the Les Schwab debt, which was a charge to provide new tires for her vehicle. So the total of his installment obligations under the court order total $4,700 per month. However, his net income and his reliable sources of income are his Social Security and his cement pension payment. Those total $3,674. I believe that's the net amount. And that leaves him approximately $1,100 per month short just to meet the court-ordered obligations, not taking into consideration his own independent needs as far as food, fuel, and just his basic needs. So our concern is at this juncture, he is in a lose-lose situation where he cannot meet all of these financial obligations. My client is nearly 70 years old. He has been retired since 2008. So he's been retired for the last, what would that be, 15 years? And he, over the years, has picked up some union work, but because he's on the retired roll, he's the last person to be picked up, one of those last people, depending upon how many retirees they have. And certainly there is no consistency to income or jobs that are available to him. In addition, the cement industry is weather dependent, job dependent, and again, depending upon who all is on those roles and available at that time that are above the ladder compared to him. And to provide sort of the differences in or the unexpectedness in those monies, we provided his information for 2022, 2021, and for 2023. In 2020, 2021, and 2022. In 2020, his gross from being on the union roll was a total of $1,365 for the year. In 2021, his gross was $20,899. And in 2022, he grossed approximately $2,400. So that's roughly $200 a month. And yet, he's saddled with these orders that even when you include that amount, he's still $900 underwater before he even meets his own financial needs as far as basic needs for food and shelter. So we're asking the court to reduce his monthly payments. And we've also, the whole goal is how can we free up some cash here? The court has the ability to take a look at this at the time of trial, listen to everybody's arguments as far as what's community, what's separate, how the court's going to allocate the different things. My client had reached out back in January about possibly refining the community and separate debts so that those could all be reduced in monthly payments. And if we did that, potentially his refinance would reduce his monthly payments from $3,450 per month to $2,567 per month. So that would be more in line with allowing him at least to pay those court-ordered obligations, but still doesn't allow him any ability to provide for food and whatnot within his own household for his own needs. Under that refinance, the only way that he will qualify according to the financial institution, which was Red Canoe Credit Union, is if his spousal maintenance is limited to $400 per month. In addition, again, with the auspice of trying to get some financial relief, his proposal is that that he be allowed to remove up to $20,000 if he can qualify for that, to bring current his payments and the like. Counsel's argument previously has been that, well, that means that she's paying half of her own, half of his obligations with her share of the equity. And again, that's an argument for trial. The goal right now is to get money to both of these folks, provide some financial relief so that we can move forward with obligations being paid and people's basic needs being met. The other argument is that, well, he needs to sell his pickup truck. So the difficulty with that is, as you know, COVID has wreaked havoc on not only the housing industry, the apartment industry, but also the vehicle industry. And vehicles, which have historically been relatively low, are now skyrocketed. Not only that, have they skyrocketed in price, we, of course, had shortages of vehicles, which contributed to that skyrocketing in price. But we've also had increases in interest rates across the board. All of this means there's less money to go around. It's the same in the grocery store. As my client points out, milk is almost $6 a gallon. It is across the board for everybody. But the suggestion that my client sell his pickup truck, what happened is originally he had another truck. That truck was totaled. There was not enough insurance money to pay off the debt because it was basically upside down. My client still has a residual amount that's owing on that pickup truck. And then he had to secure additional transportation. So he did secure transportation, a basic Ford truck. And again, because of the increase in costs during COVID and the interest rates, we are where we are. And I agree that that monthly payment is high, but that's not uncommon in this day and age. But again, if we consolidate everything, we have potentially the opportunity to lower all of these payments so that we've got something that's a lot more manageable. So there is no equity in the existing vehicle. And if he goes to try and sell that, there's likely no money that would be available from that. And then we've already got him tapped with a court order that he can't meet and other financial obligations. That means he's probably not going to have a vehicle, which means that even if he is able to get called up on the union list, then he won't have transportation to go to a job. So we're simply asking the court to recognize the actual financials of where we are. We've provided his bank statements, we've provided the tax returns, we've provided the W-2s, and we're simply asking that the court allow us some relief, reduce the spousal maintenance obligation, allow this refinance so we can try and free up some of this cash so that he has the ability to meet that, but also recognize that he too has basic needs. And again, at this juncture, Ms. Rapp is sharing expenses previously with her sister and now with another individual. She has not provided verification of those ongoing expenses or how she's spending money. And again, my client tells you in his reply declaration that what she submits in writing is definitely different than what they've been discussing. My client has never said she's not entitled. My client has never said he's not going to pay her. He has provided a $500 payment. Since we were last in court, he has provided 2 prior $700 payments before we started with all of these additional hearings. And he's at wit's ends. He needs an avenue to be able to try and comply, because unfortunately, the prior court orders set him up to fail. So that's simply what we're asking, is that the court grant the relief that's requested, reduce the spousal maintenance to the $400 per month, allow him to refinance so that we can lower these monthly payments and provide for a lump sum to bring him current. The court can trace all of that, characterize all of that, and provide for a fair and equitable distribution at the time of trial or settlement conference. And then the other was to request that the parties file jointly for 2022 Ms. Rapp is on disability, so she doesn't have any taxable income. And actually, I think she's on is it SSD or SSI? She might be SSI. I can't remember. In other words, I don't believe she has taxable income, but either way, they should file 2022 jointly and share in any tax prep costs. He is proposing that 100% of any refund go to her, with him receiving 50% of that refund as credit towards his arrears. And again, this is another opportunity where he's trying to get money in order to comply, and simply asking for that creativity that apparently Ms. Rapp is unwilling to even consider.
All right, thank you. Mr. Zandy.
Thank you, Your Honor. Court's aware I do represent the original petitioner, non-moving party to the motion before you today, Cheryl Rapp. And I would first of all submit this is now the fourth time since October we've heard the exact same argument. You are now the fourth judicial officer. I think if we go back in time to October, it was largely the same type of excuses from Mr. Rapp. I'm concerned when counsel says that he has never said he wouldn't pay her, when all along, that's all he's ever said. He's told her he just assumed go to jail before he pay her any money that she, quote, doesn't deserve. That's been litigated now for at least the third time. This has been borne out since the very beginning of arguments that the Judge Scudder, I believe, was the initial presiding officer that heard this back in October and entered the order. And true to his word, he's refused to pay her anything. Counsel states, this is all about how can we free up some cash here. Again, as all you have to do is look at past hearings. Commissioner Baldwin, during the contempt hearing, issued an order that his discretionary spending is a little bit wild considering the factors, and that he's now saying, well, I don't have any money to pay any of this. If you look at his bank statements that he's provided, and it's under the guise he conveniently states, well, that was for milk. If you look at the gas stations, the Minute Marks, the Boondocks Tavern, the Chevron stations, the amounts of money that he spent, he said, well, that was for groceries and milk. The court didn't buy that. Judge Scudder didn't buy that. Commissioner Baldwin didn't buy that. Commissioner Nelson, 3 short weeks ago, didn't buy that. And in addition to the discretionary spending that shows that he's buying alcohol, and I'll get to that here in a moment, there's also the non-compliance, in which Commissioner Nelson at the review hearing a couple weeks ago said he hasn't paid a dime since the contempt order was entered and since we were in court on the contempt. So he's now suggesting, well, I'll pay $400. It's not because I don't want to pay. It's just basically because I don't have the money. Again, let's look at the facts here. Counsel states, and getting back to her point, how can we free up some cash here? Well, I'll tell you how you do that. For starters, you cut out the alcohol. And again, the record's complete with that. He now says, well, I'd rather buy cigarettes. That's in his SIR reply. I'd rather buy cigarettes than give my wife a dime of the spousal support she's entitled to. So he's placing a higher priority on his alcohol. Oh, by the way, he's got 4 prior DUIs. And the car wreck that counsel's referencing was because he was drunk, which led to the almost $1,000 a month truck payment now that counsel argues is modest, which I think speaks for itself. He's placing alcohol over the needs of his 34-year wife. He's placing his nicotine addiction over the years of marriage to his wife of 34 years. He's placing his DUIs. And again, he has 4 of those, and his needs on the criminal side, which we understand there's still pending charges on that, over the needs of his wife. He has an adult residing with him in the family home that he's not collecting rents on. And oh, by the way, is providing this adult's car insurance. That would be a way that you could cut down on some costs. And he has a $937 truck payment. That $937 truck payment exceeds my client's entire monthly budget. So if you look at it from a practical standpoint of these parties have been married for 34 years, Mr. Rapp has always been the traditional breadwinner and the income earner. My client was at home, and he essentially is saying, well, you know what? I'd rather smoke my cigarettes while I drink my beer in my fancy truck than give you a dime in the support, which has now led to the 4th different avenue that we're seeking here. And instead of paying what has already been ordered of him, he chooses to come back to court, this time asking the court to decide something that you don't have a legal basis to decide. This issue was already argued. These merits were already discussed and contemplated by Judge Scudder back in October. He issued his ruling. He gave that order, and at no time was that order ever asked to be reconsidered. At no time was Commissioner Baldwin's findings that he has lavishly spent on discretionary income and purchases. At no time was that asked to be revised. Rather, we get this motion. Again, when we've just been to court, now this is the third time since the first of the year on his malfeasance and inability to pay or refusal to pay, and now asking for, well, I'm going to go ahead and argue the exact same facts instead in front of the fourth judicial officer and hope that something's different. He doesn't have the cause. He doesn't have the change in circumstance to make those arguments, but yet here we are debating the exact same issues. It's ironic when he states again about his cigarette purchases and his groceries and the fact that he stops by the grocery store, or excuse me, the Minute Mart all the time and just so happens to be getting those things, but can't give anything to his wife. My client filed her responsive declaration on March 8th. Up until that point, she hadn't received a dime. Commissioner Nelson at the last hearing made it abundantly clear to him, you need to take this seriously. You need to start paying because you're non-compliant. And again, that's reduced the writing in the order. You need to pay $1,000 immediately. And he comes in finally a couple of days ago and gives $500 and says, well, throw me a bone here. I even though it's less than half of my monthly obligation, I gave you something. That pales in comparison to my client's budget. He then tells you, and again, the same thing he was alleging during the fall, that my client is getting child support, that she's getting food stamps, that she's living with her sister, that she's working on a marijuana farm, all of which is speculation and has already been disproven. She's not getting child support. She's owed child support from the state for a period of time that she did have custody of her granddaughter. She doesn't expect to get that. She lives in Oregon. Living in Oregon, she's not going to qualify for Washington food stamps, as he states. She doesn't work on a marijuana farm. She's 63 years old and has rarely worked. The only time she's really worked is when she was working on the family home that Mr. Rapp is now arguing that you should allow him to refinance so he can essentially pay her a chunk of her own money. Again, that's completely unreasonable and flies in the face of just and equitable given these circumstances. If you look at income available to him, if you look at the fact that he could be getting at least $500 per month in rent from the adult resident, if you look at the fact he could cut that adult resident again from the auto insurance, if you look at the fact, and it's not about making money on this truck, it's about eliminating the payment. I'm going to use counsel's statement again. How can we free up some cash here? You don't pay $937 for a truck payment. That's how you free up some cash. You don't continue to get DUIs and crash prior vehicles. Contrary to the comments, he has other vehicles in his possession that he could drive that he would just simply fix up. There's means and there's resources here that are not being tapped into because, again, what's the overriding theme of this? It's Mr. Rapp coming before the court saying, I don't have the money to pay this, take some pity on me, and then telling my client, I just as soon go to jail than pay you a dime. And sure enough, that's what he's been on the verge of doing. Commissioner Baldwin made that clear. Commissioner Nelson made that clear. And here we are again, arguing the exact same thing that we were back in October when he felt that that wasn't fair, but rather than bring a motion to reconsider as the law requires him, he waits, completely ignores his obligation, doesn't give her a dime, but meanwhile he's buying cigarettes and beer, doesn't give her anything, and then comes back in March when he's on the verge of jail time and says, oh, by the way, can I have a do-over in front of a new judicial officer? There's no change in circumstance. There's been no detriment proven that wasn't already argued 3 prior occasions. And he doesn't have the resource, he does not have the legal ability or the factual ability to make these arguments here today. We are asking you deny the motion. My client has detailed for you her frustrations on this, the amount of money that she spent just trying to get Mr. Rapp to comply with the order. The fact that he's now suggesting on this family home, well, just let me refinance it. Commissioner Nelson heard that argument 3 weeks ago, denied that request, said it wasn't appropriate. We had ample discussion about that.
That mischaracterizes Commissioner Nelson's ruling, and the order speaks for itself.
Right, and I'm sure it's in the clerk's minutes and the order alike. Nonetheless, it's the same argument we entertained 3 weeks ago. We've been there. paying her out of that and paying her through some kind of refinance when we don't know how much he's going to qualify for, again, is unnecessary at this point and is essentially trying to pay her with her own money. At the last hearing, it was argued that Mr. Rapp is somehow tied to his adult daughter's vehicle, and that he was asking that he be allowed to refinance that his name out of that. Again, we keep having all of this gamesmanship being played by Mr. Rapp, all in an attempt to avoid his payment and his responsibility to his wife of 34 years, who he's always been in far financial superiority over. Finally, and I think it's germane if we look at some of these other issues as referenced in his declaration and my client's response there too, you're going to see kind of an overriding theme of this case of Mr. saying, well, I don't want to pay the maintenance. I would certainly submit that his pension is a community asset. His Social Security, although not an asset, can be considered for maintenance. At the time of the temporary orders, the court took both of those, combined that, recognized the fact that my client is living on next to nothing, took those considerations and ordered the $1,250. It wasn't a random number. It doesn't matter if you quantify this amount as spousal support or property, the amount comes out the same. If you take half of the just and equitable percent of that pension, it gets you right close to exactly where the temporary order is today. Granted, it requires him to make some decisions. It requires him to deal with his alcohol problem. It requires him to stop going to the mini mart and buying his milk every day in large quantities that he apparently drinks a heck of a lot of milk. It requires him to stop buying his cigarettes. It requires him to not have a $937 truck payment when my client can't even afford to drive her car because she can't afford the tabs for it. So if we look at what my client is going without, she's the party that's going without because he has all the financial ability to provide for the community and is intentionally choosing not to. And again, that's borne out by the prior findings of the court. Without a motion to reconsider, this motion today is improper. Without a change in financial circumstance, this motion is improper. Without a showing by the preponderance of the evidence that there's been some change in financial circumstance, it's improper. And again, I feel like a broken record because we've made the same arguments and had the same discussions on multiple occasions. Counsel knows what my argument is. She predicted it. She states, as counsel said in his prior arguments. Absolutely right, because again, this is the same issues that we've heard time and time again. As it relates to the tax return, my client is neutral on that. We will defer to the court. I will tell you that in the years past, they have filed separate. I'm fine if the court wants to have some kind of a joint return for 2022. And my client should not have to weigh in on the cost of that. That should certainly be Mr. Rapp. We're in this position because of his choosing and his, again, intentional violation of the court order, as evidenced by prior orders and very recent findings in that regard. He should have to bear the responsibility for that. And if my client's granted the entire return, I certainly think that's appropriate. But we would ask for another contribution in fees and costs. At every step of the way, the court has imposed fees, and to date, we haven't gotten a dime. At temporary orders, there was fees. The contempt, there was fees. And most recently on the review, Commissioner Nelson imposed more fees because he's just not complying and not doing what he's supposed to. We are asking for fees and costs. My client is literally going backwards because the orders of the court are not being followed by her husband of 34 years because his priority is cigarettes, beer, and a Ford pickup truck.
So just briefly in response, obviously, folks come into a case with a lot of history, and that history includes the fact that when this case started, Mr. Rapp had a $900 and some vehicle payment. So that's not something that was incurred subsequent to this matter being entered. Those are the facts that we had at the time that this temporary order was heard. If you go back and look to Ms. Rapp's financial declaration that was filed with the court, she claimed that my client's net income was $5,166. We have shown through the 2022 documentation that his current net income is roughly $3,600 per month. That is a substantial change in circumstances because they continue to argue that he has about $5,200 per month in net income, which is not factually accurate. Council continues
I'm going to object, Your Honor, to any conjecture. That's what we argued in October was not a finding of the court. That's not the basis for a change in circumstance.
I'm not sure which side of
There's
the
no
mouth
findings
is
that he
being
made
argued from at this
$5,200 that I'm
point.
aware of.
All right. The current amount ordered is $1,250 a month, correct?
Correct.
And there hasn't been a month since that was imposed that he's paid that in full. Is that correct?
Not even close. Correct.
He's made
And
$700 payment and one $500 payment.
And on the 28th of February, it appears that Commissioner Nelson imposed an additional $500 in attorney's fees and that $1,000 needed to be paid before the hearing on the 15th of March. Is that correct?
No, before April 4th. $1,000 needs to be paid before April 4th, not March 15th.
Okay, it's not clear from this, so I don't know if there was an order.
Page 2 of the order. The order was just entered on March 15th. That's when our hearing was, or that's when our presentation was.
Okay.
And the court order at paragraph B that he's to pay $1,000 towards his spousal support before the review hearing on April 4. He has now paid $500. $500 of that $1,000. And Commissioner Nelson, under the findings, indicates that the request to refinance did not qualify as a payment plan, which was the basis for the review.
He's under court order to pay $1,250 per month in his basic support obligation. Commissioner Nelson wanted $1,000 paid towards what he's already owed that he's not paid since the order was entered back in October. And to date, he's paid $500.
So without interrupting counsel, if I could continue, the findings by Commissioner Nelson were that the review hearing was to see what had been paid and or if he had a payment plan. And the court, Commissioner Nelson found that the request for the refinance was not a payment plan.
Okay. All right. So I've gone back. I reviewed pretty much everything. Pretty much everything in this case. I reviewed pretty extensively the minutes from the hearing in front of Judge Scudder, October 11th, the hearings in front of Commissioner Nelson, the hearings in front of Commissioner Baldwin, or hearing in front of Commissioner Baldwin. Frankly, given the combination of circumstances, $1,250 a month seems appropriate, and I'm not inclined to change that at this point in time. So I'm going to deny the motion. If the 2022 taxes, filing those joint with the return to Mrs. And some credit given to Mr. Isn't objected to by Mrs., then I will make that order. So that process can begin.
Of course, assuming there is a return or a refund and he's paying to have that done.
Yeah, if there's a professional filing done, yeah, I think he would be responsible for that. If frankly, the benefit for that would be to him, so I think he would be responsible for paying for those the preparation, and then assuming there is a return, it goes to her, and with some credit towards him. If there is not a return, then I guess we're in a different circumstance.
So you do have a proposed temporary order. You should have a proposed temporary order before you.
Let's see here.
And are you just reserving on any issues about the refinance of that house, given we don't know if it's community or separate or what is which at this point?
I'm not making a finding on that at this point.
So he can or cannot proceed with that.
At this point, no.
Okay.
So, let's see.
I would prefer we get a fresh order.
Yeah, there would be a lot to
Represent
change
that.
on this one.
I don't think that there would. I think at paragraph 5, you simply indicate that the request is denied.
Both A and B.
Yes. Oh, I guess you could keep B, sorry, if you already struck through that. And just indicate that A is denied. And then at 14A, the second sentence, just indicate, if you strike out the first part of that and just indicate the respondent pays 100% of any tax preparation costs. And then 14B would be denied.
Are you making any further orders about attorney's fees for the amount of time that we've been here today?
So I'm going to go back to number 1.
We would simply ask that the court reserve that for the time of trial, given the different issues that are involved in this case.
I'm going to impose $500 in attorney's fees today for this motion. I don't, I know that may seem to Mr. Rapp that things are just getting piled on, but I frankly think the record shows that we're here because of him. So I'm including that under number 1. Obviously, the language isn't there on interest and all that, so I don't know if you want to supplement Mr. Zandy with an additional.
That's kind of why I think if we just cleaned up the order and presented that, that would probably make sense.
My withdrawal is effective tomorrow. I've filed a withdrawal in this case that's effective tomorrow.
So, Mr. Zandy,
I won't be here for a presentation.
okay. So I don't know, Mr. Zandy, if you just want to put that on in a week or two for presentation?
Yeah, let's, you're not here next week, so I guess we can, I'd rather not do it on the 31st. Can we do it on April 5th or 4th, whatever the next?
Sure.
I'll draft that order.
Okay. April 4th, 1 p.m. And then I will shred this one that I tried to redo.
Okay.
Okay. Thank you.
All right. Thank you all. We can go off the record.